All right, folks, we're going to turn our attention now to Ohio, where this morning an appeals hearing got underway for defendant Brenda Powell.
She was found guilty last year of murder, felonious assault, and tampering with evidence after she hit her mother, Brenda Powell, with a frying pan and stabbed her about 30 times. Now, Sydney, who was only 19 at the time of the murder, had been arguing with her mother after it was revealed that she'd been kicked out of school.
Body cam video resurfaced following Sydney's conviction, showing police drag her out of the home where her mother lay inside, battered and bloody, on the bedroom floor. Take a look.
Take her outside.
Come on. Come on.
Is she gonna be okay?
Come on. Come on, come on. You just need to cooperate with me, all right?
I want my dad.
Huh?
I want my dad.
What happened? What's going on? What's going on?
We heard a bang. We heard a bang. And she told me to get out. And then I heard screaming. So I came back and she was on the ground.
Okay, you heard a bang.
There was a bang. Someone broken.
Today, an appeals court agreed to hear the defense team's argument for a new trial after they claimed prosecutorial misconduct and accused the judge of denying their request to present a surrebuttal case if needed after the state presented their rebuttal. The rebuttal by the state was of an expert. The defense said, we now want to do a surrebuttal defense witness in response to the state's expert, correct?
Mm-hmm.
Let's make sure we lay it all correctly. So now we want to go in to hear from the defense just earlier today in this appellate argument.
This was not a whodunit. There was no dispute that Sydney's mother's death was caused by Sydney. The only issue for the trial was that of NGRI, on which the appellant carries the burden of proof. So what happened at trial was the state did not call a single expert, which, by the way, it only identified one expert. It did produce an expert report under Criminal Rule 16K. But that expert report turned out to not actually include many of the key opinions that the expert had testified to. In the defense case in chief, the defense called three preeminently qualified psychologists. Dr. Reardon, who was a former team psychologist for the United States Olympic team. He met with Sydney for 8 to 10 hours, put her through a battery of tests designed to decide, number one, what her sanity was at the time of the act, and number two, whether she was malingering at the time of the act or feigning, or in other words, faking a severe mental disease or defect. And Dr. Reardon concluded that he had rarely, if ever, seen a situation where an individual was in such an utterly compromised psychological state as Sydney Powell at the time of the offense. The state also called Dr. Swales. He's a forensic neuropsychologist. He was a professor at Case Western University, board certified, published. He spent 15 hours meeting with Sydney, putting her through these tests, which are recognized in the field of psychology of having merit. He's even taught a class to determine on the psychological test for detecting malingering. And he, like Dr. Reardon, reached a conclusion that at the time of the event, Sydney met the legal standard for not guilty by reason of insanity. And finally, the defense called Dr. Timmy, another psychologist who had testified in 100, provided an opinion rather, in 100 NGRI cases where the person he was studying was facing the risk of prosecution, criminal conviction. And in only 5 to 10 of those cases out of 100 did he come to the conclusion that the person he was studying did meet the legal definition of insanity. This was one of them. And the crux of all of these experts' opinions were through recognized testing in how do you determine if somebody was malingering at the time of the event? How do we determine what somebody's mental state was at the time of the event? On rebuttal, the state called Dr. Abradovich, and by contrast to the appellant's experts, this was her first time testifying at trial on these issues. She holds no memberships, not board certified, she doesn't teach. She spent just 2 hours with Sydney. The defense experts spent collectively in excess of 30 hours with Sydney putting her through these tests. And importantly, she ran no tests. And when she was on the stand for the first time, she attacked the methodology of the appellant's expert's tests. And this was the first time we heard this. She said, you know what, I didn't run any tests because those tests don't tell you anything about the time of the event. They only tell you about the time in which you are conducting the tests. That was not previously disclosed, and that is against the science.
And counsel, you were permitted to cross-examine Dr. Obranovich regarding that testimony, correct?
There was cross-examination by trial counsel, that's correct.
And is it the argument that without the SIR rebuttal, you were not effectively able to contradict or counteract that testimony, that the cross-examination allowed was not sufficient?
That's correct, Your Honor, because it's the first time we're hearing these opinions is during SIR rebuttal. Number one, it robs trial counsel, the opportunity to effectively prepare for cross-examination on new subjects. And number two, without having an expert being able to come and take the stand and explain to the jury the methodology of why what this person is saying is incomplete, I mean, that really goes to the fairness of this trial, and it allowed the state to have the last word on this, on new opinions that were not disclosed in the report.
Again, this is an appellate argument. It's a little different than a trial. It's not a trial. He's making this argument specifically about this state expert who testifies and basically says, oh, those tests wouldn't have been any good, wouldn't have done anything. Those tests being what the defense expert had testified to. And the defense is saying cross-examination wasn't enough. We should have been allowed to call another expert to refute that.
Yeah, I believe the specifics are, they're saying she didn't refute the testimony of the experts in terms of their conclusions.
Right.
She did. She went against the methodology.
Yes.
And because we didn't have any way to refute that in our original testimony, we should have been given the opportunity to bring an expert in to question her questioning of the methodology. And so I think they're making a lot of sense, but, you know, well, let's hear what the state has to say. Let's take a break here. When we come back, we'll hear what the state has to say. Then we'll get Jack involved. He's got some real opinions on this as well. So stick around. We'll have that all coming up next. Keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, a Tennessee man's life hangs in the balance after being convicted of felony murder. We'll bring you the latest in this high-stakes penalty phase.
Closing Arguments, tonight at 8/7 Central, only on Court TV. This week.
What to know before the day's proceedings in the investigative reporter murder trial. Plus, a deeper dive into the big trials coming up with our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Turning now back to Ohio, where convicted murderer Sidney Powell was back in court this morning asking for a new trial. A jury rejected Powell's insanity defense last year and instead found her guilty of fatally stabbing her mom after it came to light that Powell had been kicked out of school.
Well, now Powell's defense team is asking for a new trial, saying that the judge didn't allow them to present a SIR rebuttal to the prosecution's mental health witness, and that prejudicial photos and testimony about the victim's death were allowed into evidence as well. Now, we just heard from the defense, so let's hear what the state has to say.
I think it's important that this court not disturb the jury's verdict on appeal, overrule the assignment to bear, and affirm the convictions. I will similarly limit my argument today. The appellant's counsel says it's about the first assignment of error. It seems like it also goes to the second assignment of error. So I will address primarily those two unless our questioning takes us elsewhere. And I do think that we need to add some context here. Although expert testimony was important in this case, I think there are some critical facts that have been left out of our presentations this morning regarding the defendant's conduct immediately after the murder occurred. Most notably that she staged the crime scene by breaking out a window, by opening the door, that she lied to her father and police officers about someone breaking into the house, that she even took on the victim's identity in a phone call with not union officials. And that's a common sense premise that when someone takes such steps to cover up their own wrongful actions, they clearly appreciate the wrongfulness of their actions. And I cite in my brief to this court a wealth of case law holding that. It is just something that we innately understand, regardless of how many expert opinions may tell us that they have a different opinion on it. It is something that jurors are able to hear and consider. So with that, from there, I would just emphasize there are serious problems with the trial counsel's proffer statement about what he expected Sir Rebuttal to look like. It really amounted to an argument with his disagreements with Dr. Bradovich's testimony. The proper forum to litigate that and argue about that is in closing arguments. You don't get an automatic right to Sir Rebuttal to re-present evidence that's already been presented. And I put a chart in my brief, all the items that he outlines in his proffer, and the testimony from their experts that address those topics. And I would say that, these methodology complaints, those experts all testified why they used that methodology, why it was appropriate in their view, in their professional judgment, and why they thought that they were accurate results. Those were all for the jury to consider and for the arguments to go. It's clear there is no right to Sir Rebuttal. I can't ask for it today. There's no right to re-present cumulative evidence and just be last. That's not the way our laws work.
All right, still with us here in studio, we have Jack Rice. Jack, the state's saying it very clearly, there's no automatic right. We knew that. It's the court's discretion to allow Sir Rebuttal or not. It's rare. It's not often done. What are your thoughts?
Yeah, well, I can understand both sides of this one. Let's think of it this way. When prosecutors will put an expert on, the defense will then put somebody on in response to it. Frequently, you will see prosecutors then rebut that with another expert or maybe even the same expert to answer those questions. In this particular case, they didn't put any experts on. The defense came in with experts, 3 in fact, and then we had one expert from the state who came in rebuttal to that, and their response was they made some arguments that we never heard before, and so therefore we have the right to bring somebody else to respond to those. Basically saying, from a due process standpoint, if the state gets to do this to us in general, we should have the right to have that same right, because this is about some very serious issue regarding this young woman and mental illness. What we get from the state is just the opposite, saying, you know what, there was nothing new here. Nothing at all. And so therefore, they should have seen this coming. The right place to argue this was at closings. Because they failed, that's not enough. Yeah, and again, Sir Rebuttal is rare for the reasons that the judge or the court doesn't want these things to keep going because maybe one side or the other thinks that they made a mistake. And I think that's kind of where the state was going, saying, look, methodology is the way you attack experts. How can you be claiming now that you didn't know that this was coming and you should be given the opportunity to bring another expert?
Because this that's is not part of the foundation, too. Yeah. Sorry to interrupt, but the methodology is at the foundation of the expert's opinion.
They do. And it's not this it's not direct cross redirect where you're basically narrowing it down. This is different than that. And so based upon where we are here, we're saying, guess what? You had your shot. This was nothing new. Now what you should have done is gone after our witness and said, you don't know what you're talking about. You didn't address the issues that needed to be addressed. And we were right. You were wrong. And you get to do that during closings. That's exactly what the state is arguing.
Do you think it's effective, Jack, for the state to also go to the broader bird's eye view of do not, Court of Appeals, disturb the jury's verdict?
You know what? Courts of appeals love jury verdicts. They do, and they hate to overturn them unless they're almost backed into a corner. I've seen it so many times where they say, and this is the non-legalese version of it, no harm, no foul. Jack, there was one other issue that they argued. We didn't show this part, but basically the defense claimed that they made an error, the court made an error in allowing the state to bring in front of this jury information that this defendant said that she didn't want, when she was in the hospital after this event, she didn't want to talk to anyone but her attorney. And they kind of used that to suggest, hey, why wouldn't a guilty person only do this? That was the implication. It's a very serious accusation, very serious constitutional right. What do you make of that claim? Yeah, you know, I understand the argument that's been made, but sometimes I've seen that happen before. You'll actually see this where you'll say, well, they want to talk to their attorney, which has some implication, this presumption of innocence, but your right to counsel. The problem is that sometimes juries can jump to conclusions. That's the fear. My fear in a case like this is now we're talking factual issues, and it's a much different question than that. I think that other one regarding Sir Rebuttal may actually have a little bit more staying power.
All right, and Court of Appeal issues an opinion to tell everyone what they decided. They don't stand there and say this is what we're going to do. So thank you so much for Jack Rice for joining us this hour.